Good morning, everyone. My name is Sampa Karmkar Singh. I am Assistant Professor at NUJ's Kolkata. Today, we are going to discuss about inheritance and succession laws under Christian and Parsis. Black's Law Dictionary defines inheritance and succession as the term inheritance has been defined as property received from an ancestor under the laws of intestacy, property that a person receives by bequest or devise. The dictionary further defines succession as the acquisition of rights or property by inheritance under the laws of descent and distribution. Inheritance may be termed as a means to an end, that end being succession. There are two kinds of succession. Let us first start with intestate succession. Then we'll discuss about what is testamentary succession. And these are the two kinds. Intestate succession means when a person dies without making a valid will. Based on the religion of the deceased, the property owned by him or her is distributed following the common law of descent applicable under his or her personal law. It is also termed as hereditary succession. In our country, we don't have uniform civil code, and these are succession laws or inheritance laws. These are governed by the personal laws of the person, and personal laws, it varies from religion to religion. Coming to the next kind of succession, that is testamentary succession. When a person dies leaving behind a valid will that states how his or her assets and property should be distributed after his or her death. Coming to Christian intestate succession. A landmark case in this regard is Mary Roy versus State of Kerala case. In this case, the validity of Section 24, 28, and 29 of the Travancore Christian Succession Act 1916 was challenged. It was contended that the sections are in violation of Article 14 of the Indian Constitution. This case held that the intestate succession to the property of Indian Christians in the territories of the former state of Travancore is governed by the provisions which are contained in Chapter 2 of Part 5 of the Indian Succession Act 1925. Coming to Indian Succession Act 1925, the general provisions under this Act 1925 relating to interstate succession are based on the laws of England. Both immovable and movable property could be inherited under this Act. It lays uniform rule for devolution of property for both male and female dying intestate. The shares inherited by the heirs, including female heirs, are absolute and freely alienable. Alienable means they can transfer it also. Coming to Part 5 of this Act, it contains the provisions relating to the intestate succession. It deals with the intestate succession of the Christians. Chapter 1, it starts with section number 29 and 30. This part actually is the preliminary part of this Act. Chapter 2 talks about section 31 to 49, which deals with rules in cases of intestates other than Parsis. So here you could see that it clearly mentions that it will be applicable to intestates other than Parsis. So Christians will be covered under this chapter. Chapter 3 talks about the special rules for Parsi intestates, and it is contained from section number 50 to 56. Coming to section 33, so let us first start with the Christian law. Where intestate has left widow and lineal descendants, or widow and kindred only, or widow and no kindred. So here you could see that there are three different circumstances where the intestate has left a widow, say for example. Then if he has also left any lineal descendant, in such a case, 1/3 of the property shall belong to his widow, and the remaining 2/3 shall go to his lineal descendant. So let me give you one illustration here. Suppose A is a Christian who died leaving behind his wife B and two children C and D. So here, after his demise, the widow will get 1/3 of the property, and the children will get from the rest 2/3 of the property. They will divide it in equal shares. Next rule says, if he has left no lineal descendants, means there is no children, but has left persons who are of kindred to him, one of of his property shall belong to his widow, and the other half shall go to those who are kindred to him. So here the interesting part is that there is no children, but there are other kindred, means other relatives are present. In such a case, the widow will get half. In the presence of children, she will get one third, but in the absence of children, the widow's share will increase and it will become one half of the property. Coming to the third rule, if he has left none who are of kindred to him, the whole of his property shall belong to his widow. And interestingly, if suppose no other kindred or no other relative is also present who can take the property, in such a circumstance, in the absence of the kindred, the entire property will go to the widow. Section 33A. This section provides for statutory legacy for Christian spouses who are to inherit property in the absence of lineal descendants. It is suggested by the Law Commission of India that this section be redrafted to remove the ambiguity and be made explicit and unambiguous and applicable to the surviving spouse belonging to the entire Indian Christian community. In case of total intestacy and in the absence of lineal descendants, the Law Commission has also suggested that the sum as well as the rate of interest be appropriately increased, taking into consideration the fall in the value of rupee since 1926, increased cost of living, etc. So if you see that provision, you will find that it talks about 5,000 rupees and it also talks about 4% of interest. So these both of them needs to be increased considering the current situation. Section 34, it talks about where interstate has left no widow and where he has left no kindred. Where the intestate has left no widow, his property shall go to his lineal descendants or to those who are of kindred to him, not being lineal descendants. If he has left none who are of kindred to him, then the property shall go to the government. Now, this is under the doctrine of escheat. So, when nobody is there, who is the, suppose that person has left behind no one, neither the widow nor the lineal descendants, means the children or grandchildren, or suppose no kindred, brother, sister, nobody is there. In that case, the property cannot remain without the owner. And in such a circumstance, the property will go to the government and government will take over the property under the doctrine of escheat. The interesting thing of the doctrine of escheat is that government will not only take the property but also government has to do everything whatever a legal heir could have done in such a circumstance. So the government also has to perform the duties of the legal heir in such a circumstance when the government is taking over the property of the deceased. Section 35, it talks about rights of widower. A husband surviving his wife has the same rights in respect of her property if she dies intestate, as a widow has in respect of her husband's property if he dies intestate. So the rules are very simple. If there are children along with the widower, then one third will go to the widower and two-thirds will go to the children and they will distribute it amongst themselves equally. Suppose there is only one child, so the entire two-thirds will go to that child. If suppose there are two children, in that case that two-thirds will be subdivided into two parts. So that way you have to see that how many children are there and accordingly you have to distribute it by calculating their share. This provision provides equality to both husband and wife and they have exactly the same right over the property of their spouse in case any of them dies. Section 36, it talks about the rules of distribution. The rules for the distribution of the intestate's property after deducting the widow's share, if suppose he has left a widow, amongst his lineal descendants shall be those contained in section 37 to 40. Firstly, the widow's share will be deducted, and then from the residue, the lineal descendants will get their share. So as I just discussed with you all, that suppose widow is there, in that case one third property will be given to the widow, and the residue means the rest two-thirds, that is the residue, that will be shared by the lineal descendants. We have discussed that if there is no children, no lineal descendant, in that case widow's share increases to half. So again you have to see, depending upon case to case basis, the shares may fluctuate, it may vary. But what you need to remember is the calculation of the share. So if widow is alone and there is no children, in that case the share will be different. In the presence of children, the share will be different. In the presence and absence of the kindred, in the absence of lineal descendants, again the share of the widow will be different. Where intestate has left child or children only. Where the intestate has left surviving him a child or children, but no more lineal descendants through a deceased child, the property shall belong to his surviving child, if there is only one, or shall be equally divided among all his surviving children. Where intestate has left no child but grandchild or grandchildren. Section 38 of the Indian Succession Act 1925 is very interesting. Where the intestate has left no surviving children, but he has left a grandchild or grandchildren, and no more remote descendant through a deceased grandchild. The property shall belong to his surviving grandchildren, if there is one, or shall be equally divided among all his surviving grandchildren. So here you could see that if suppose only grandchildren are there, then you have to calculate it depending upon the number of the children. Let me give you one example here. The first illustration says A has three children, John, Mary, and Henry. They all die before the father. Here the father is A. John before his death, John has two children. So when he died, he left behind two children. Mary left three children and Henry left four children. After that, the father also died, means A also dies, intestate. And he left these nine grandchildren. So two of John, three of Mary, four of Henry. It comes to nine grandchildren. And there is no descendant of any deceased grandchild because all these nine grandchildren are alive. So the share of the property will be 1/9 each. Means every grandchild will get 1/9 share in the property of their grandfather, who is A in this case. Why? Because A's children are dead. So property will directly move to the grandchildren. Coming to the next illustration. Suppose Henry has died, leaving no child. Now in that case, the total property will be equally divided between the five grandchildren. And this is related to the first illustration. So suppose John has two children, Mary has three children. Now Henry dies, leaving behind no children. So his share also will be divided into John and Mary's children. So now the grandchildren are in number, they are five. So it will be equally divided in five parts amongst the children of John and Mary. Section 39 says, where intestate has left only grandchildren or remoter lineal descendants. In like manner, the property shall go to the surviving lineal descendants who are nearest in degree to the intestate, where they are all in the degree of grandchildren to him, or all are in a more remote degree. Coming to section 40, where intestate leaves lineal descendants, not all in the same degree of kindred to him, and those through whom the more remote are descended are dead. If the intestate has left lineal descendants, means his children, who do not all stand in the same degree of kindred to him, and the persons through whom the more remote are descended from him are dead, the property shall be divided into such a number of equal shares as may correspond with the number of lineal descendants of the intestate who either stood in the nearest degree of kindred to him at his decease or at his death, or having been of the like degree of kindred to him died before him, leaving lineal descendants who survived him. One of such share shall be allotted to each of the lineal descendants who stood in the nearest degree of kin to the intestate at his decease. Now, when we say nearest degree, so how you have to calculate the degree? Suppose the person who died, his father, his grandfather, his great grandfather. So if you calculate it from, if suppose the person himself is the first degree, then his father will be second, his grandfather will be third, and his great grandfather will be fourth. So you could see that you have to calculate the degrees and you have to find out that who is how they are connected to each other. So the father and son relationship, they are related to each other in the first degree. That son's relationship with his grandfather is of second degree. And with grandfather, great grandfather, it will be of third degree. So the degrees you have to calculate. Okay. And one of such shares shall be allotted in respect of each of such deceased lineal descendants, and the share allotted in respect of each of such deceased lineal descendants shall belong to his surviving child or children or more remote lineal descendants, as the case may be. Such surviving child or children or more remote lineal descendants always taking the share which his or their parent or parents would have entitled to respectively if such parent or parents had survived the intestate. Let me simply give you one illustration here. This will help you to understand the previous two clauses which we just discussed. Illustration number 1 says, A has 3 children, John, Mary and Henry. John died, leaving 4 children. Mary died, leaving 1. And Henry alone survived the father. On the death of A, and he dies intestate, 1/3 is allotted to Henry, 1/3 to John's 4 children, and the remaining 1/3 to Mary's 1 child. So here you can see that the whoever has survived A, they are in different degrees. A's relationship with John, Mary, and Henry is of father and son, but A's relationship with the children of John and with the children of Mary is of grandson or granddaughter. So the degrees are different, right? So if suppose in this case, you could see if in the previous example also we have seen that if John, Mary, Henry all died, then the property directly moves to the grandchildren. However, suppose if one of the child is alive, in that case, in this degree only, the property will be divided into 1/3 each. So John will get 1/3, Mary will get 1/3, and Henry, as he is alive, he will get 1/3. Now, out of as John and Mary are dead, so out of what 1/3 they have received, their children will equally divide that 1/3 amongst themselves. Coming to the next illustration, A left no child, but left 8 grandchildren and 2 children of a deceased grandchildren. The property is divided into 9 parts because one grandchild is deceased. So he has left 8 grandchildren who are alive and one grandchild who is dead, but the total number is 9. So the property is divided firstly into 9 parts, one of which is allotted to each grandchild, and the 1/9 which is given to the deceased grandchild as he is dead, it will be divided among the 2 children of this deceased grandchild equally. Illustration number 3. A has 3 children, John, Mary and Henry. John dies leaving 4 children and one of John's children dies leaving 2 children. Mary dies leaving 1 child. A afterwards dies intestate. 1/3 of his property is allotted to Henry because Henry is alive. 1/3 to Mary's child because Mary has only 1 child. So the entire 1/3 of Mary will go to that single child. And 1/3 is divided into 4 parts because John has left behind 4 children. Okay. So out of this one third first, that one third will be divided into uh, further four divisions. And here, John has three surviving children and one is deceased, who has left behind two grandchildren. So, John's children, out of these four children, the property will be again divided into four parts, and out of these four parts, three will be taken by the surviving children. The fourth remaining part will be equally divided amongst the two grandchildren of John, because John is dead. So it will be divided amongst his children. A has two children, John and Mary. John dies before his father, leaving his wife pregnant. Then A dies, leaving Mary surviving him. And in due time, a child of John is born. A's property is to be equally divided between Mary and the posthumous child. Interesting thing here is that when we talk about the rights of or property rights of a child who is in mother's womb, the child gets the right, even though the child has not taken birth, he is just in mother's womb. Okay. But the only condition related to the rights of a child in mother's womb is that the child has to take birth alive. If the child takes birth alive, the child gets the property right. Distribution where there are no lineal descendants. Section 41 provides rules of distribution where intestate has left no lineal descendant. Lineal descendant means his son, grandson, great-grandson, these relations. Where an intestate has left no lineal descendants, the rules for the distribution of his property after deducting the widow's share, if he suppose he has left a widow in such cases, then the section which is contained from section number 42 to 48, they will be applicable in such a circumstance. Starting from section 42. Section 42 says where intestate's father living. If the intestate's father is living, he shall succeed to the property. This is a discriminatory provision because suppose the intestate has left behind both father and mother living. Now in that case, in the presence of father, mother gets no property right from the child's property, deceased child's property. So this is something which is discriminatory, which makes the parents into two different categories. Law Commission of India, in its 247th report, which was related to the Indian Succession Act, it came in the year 2014, they have suggested that this discriminatory provision against Christian mother should be reworded and the word father should be replaced with parents to include the mother within the section's ambit so that both the parents, means both mother and father, will get equal share. However, this is only the recommendation of the Law Commission in its 247th report. But the law is what we discussed, means in the presence of father, mother will get nothing. So this recommendation has not yet came as a part of the law. So please remember that when we talk about the recommendations, on the basis of the recommendations, sometimes the courts, they take their decision, they give their judgments, their verdicts. However, if it is not part of the legislation, in that case, you have to follow the legislation itself, no matter whatever suggestion the Law Commission of India has given. That is not the law, but that is something which, on the basis of the recommendations, the laws in our country are drafted. So it is very important. Coming to section 43, where intestate's father dead, but his mother, brothers, and sisters living. If the intestate's father is dead, but the intestate's mother is living, and there are also brothers or sisters of the intestate who are living. In such a circumstance, suppose there is no child living of any deceased brother or sister, the mother and each living brother or sister shall succeed to the property in equal shares. Let me clarify it with the help of an illustration. Suppose A dies intestate. He is survived by his mother and two brothers of full blood, John and Henry. and a sister Mary who is the daughter of his mother but not of his father. Means she is connected with A through the mother, and the relationship is of uterine blood because the mother is same but fathers are different. The mother takes one fourth, each brother take one fourth, and Mary, the sister of half blood, she also takes one fourth. Were intestate's father dead, and his mother, a brother or sister, and children of any deceased brother or sister living. If the intestate's father is dead, but the intestate's mother is living, and if any brother or sister and the child or children of any brother or sister who may have died in the intestate's lifetime are also living, then the mother and each living brother or sister and the living child or children of each deceased brother or sister shall be entitled to the property in equal shares. Such children, if more than one, taking in equal shares only the shares which their respective parents would have taken if living at the intestate's death. Let me again clarify it with the help of illustration, because when you read these provisions, sometimes it is very much confusing. But the illustrations which is provided in these sections are very supportive and they will help you to understand the gist of the section, that actually what they want to say. So the illustration is A, the intestate, who has not, intestate means a person who died without making any will. He leaves behind his mother, his brother John and Henry, and also one child of a deceased sister Mary, and two children of George, a deceased brother of the half-blood, who was the son of his father, but not of his mother. The mother takes one-fifth. John Henry also will take one-fifth. The child of Mary will also take one-fifth, and the two children of George divide the remaining one-fifth equally between them because George is predeceased. So here you could see that they don't make any kind of discrimination against full blood, half blood, or uterine blood. Section 45, it talks about where intestate's father dead and his mother and children of any deceased brother or sister living. If the intestate's father is dead, but the intestate's mother is living, and the brother and sisters are all dead, but all or any of them have left children who survived the intestate, the mother and the child or children of each deceased brother or sister shall be entitled to the property in equal shares. Such children, if more than one, taking in equal shares only the shares which their respective parents would have taken if living at the time of intestate's death. Let us again clarify it with the help of an illustration. One example. If the intestate leaves no brother or sister but leaves his mother and one child of a deceased sister Mary, and two children of a deceased brother George. The mother takes one third, the child of Mary takes one third, and the children of George divide the remaining one third equally between them. Section 46 talks about where intestate's father dead, but his mother living, and no brother, sister, nephew, or niece. If the intestate's father is dead, but the intestate's mother is living, then in such case there is neither brother, nor sister, nor child of any brother or sister of the intestate. In such circumstance where nobody is present, the property shall belong to the mother. Coming to section 47, where intestate has left neither lineal descendant, nor father, nor mother. Now this is very interesting and tricky situation, where the intestate has left neither the linear descendants, there is no child, nor father, nor mother. The property shall be divided equally between his brothers and sisters and the child or children of such of them as may have died before him, such children taking in equal shares only the shares which their respective parents would have taken if living at the time of intestate's death. Section 48 talks about where intestate has left neither lineal descendant, nor parent, nor brother or sister. Where the intestate has left neither lineal descendant, nor parent, nor brother, nor sister. His property shall be divided equally among those of his relatives who are in the nearest degree of kindred to him. illustration is, suppose A, the intestate has left a grandfather and a grandmother, and no other relative is standing in the same or the nearer degree of kindred to him. They, being in the second degree, will be entitled to the property in equal shares, exclusive of any uncle or aunt of the intestate, uncle and aunt being only in the third degree. So let me make you understand that how you calculate these degrees. Suppose A, his father, they are connected with, A is connected with his father in first degree. His grandfather is connected to him in second degree. Okay. And the uncle is connected through the grandfather. Okay. So uncle is not directly connected with the father. He is connected through the grandfather because grandfather has, suppose, two children, the uncle and his father. So they are connected by blood through the grandfather, the uncle. So here uncle is in the third degree. So first degree is father, second degree is grandfather, and third degree is uncle because uncle is connected through grandfather. So here in this case, the grandfather, as he is the second degree, so he is more closer as compared to the uncle. And the uncle and aunt, they are in third degree. That's why the grandfather and grandmother, they will get preference, and as they are standing in the second degree. So they are nearer degree of kindred to the deceased. And that's why they will get. So whoever is nearer in the degrees, they will prevail over the remoter degree of the kindred. Second illustration is A, the intestate has left a great grandfather or a great grandmother and uncles and aunts, and no other relative is standing in the same or a nearer degree of kindred to him. All of them are in third degrees, and that's why they will get equal share. As we have discussed in the previous illustration, suppose if you are calculating A's property, so his relationship with his father is in first degree, grandfather is in second degree, great grandfather is in third degree, and from grandfather, uncle and aunt are also connected, so they are also in third degree. So here great grandfather and uncle and aunt all are in third degree. That's why their share will be equal. Next illustration is A, the intestate left a great grandfather, an uncle and a nephew, but no relative is standing in the nearest degree of kindred to him. All of these being in the third degree will take equal shares. Fourth illustration is 10 children of one brother or sister of the intestate and one child of another brother or sister of the intestate. Now here it constitutes the class of relatives of the nearest degree of kindred to him, and all are same. They all will get 1/11th of the property, no matter 10 child of one brother and one child of one sister. Okay, because the brother and sister, both of them are dead. So all these children are connected to this intestate in the same degree, and that's why all are in the same category, same class of relatives. So the property will be divided into 1/11 because the total number of children here in such case is 11. Section 49, it talks about children's advancement not brought into hot pot. Where a distributive share in the property of a person who has died intestate is claimed by a child or any descendant of a child or such person, no money or other property which the intestate may during his life have paid, given or settled to or for the advancement of the child by whom or by whose descendant the claim is made shall be taken into account in estimating such distributive share. With that, now we come to the special rules for Parsi intestate succession, because from section number 50 to 56, it is the Parsi intestate succession, and it is provided under Chapter 3 of the Indian Succession Act 1925, which provides the special rules for Parsi intestate succession. It is interesting to note that Chapter 2 of this Act is titled as Rules in Cases of Intestates Other than Parsis, but Chapter 3 is titled as Special Rules for Parsi Intestate Succession. So a clear distinction, you can see that which chapter is applicable to Parsis. Section 31 of the Indian Succession Act further mandates that Chapter 2 shall not be applicable to Parsis. Now coming to the first section, which is applicable to Parsis, it starts with section number 50, which talks about the general principles relating to intestate succession. The first rule is the first clause. It says there is no distinction between those who were actually born in the lifetime of a person deceased and those who at the date of his death were only conceived in the womb but who have been subsequently born alive. As we have discussed when we discussed the Christian law, that child who is in mother's womb means after the child has been conceived, the child has the property rights. The interesting thing is that only the condition is that the child has to take birth alive subsequently. If the child takes birth alive, the property rights revolves on this child. So under the Parsi laws also, there is no distinction between a child who is actually born or a child who is just conceived at the time when the person died, whose property we are talking about. Next rule is that a lineal descendant of an intestate who has died in the lifetime of the intestate without leaving a widow or widower or any lineal descendant or a widow or widower of any lineal descendant shall not be taken into account in determining the manner in which the property of which the intestate has died intestate shall be divided. So here the interesting thing is that if suppose A is the A is the person who died and he left behind two children, B and C. Okay, and C is predeceased. Okay, so suppose A has two children, and when he died, that time only B was alive and C was dead, and she was unmarried. There was no wife, no children, no lineal descendant, nobody. So in these cases, the share of C also will go to B. So when you are calculating, you will not take this deceased person into the calculation. So the entire property will go to B in such a scenario. Rule number C says where a widow or widower of any relative of an intestate has married again in the lifetime of the intestate, such widow or widower shall not be entitled to receive any share of the property of which the intestate has died intestate, and such widow or widower shall be deemed not to be existing at the intestate's death. So it is about the widow and widower or of the relative with whom the intestate is connected and that person has remarried. So in such cases, the person will be treated as not part of the family and no share will be given to them after remarriage. Section 51 talks about the division of intestate's property among widow, widower, children and parents. Where such Parsi dies, leaving a widow or widower and children among the widow or widower and children so that the widow or widower and each child received equal shares. Let me give you one example. Suppose X is a Parsi male. He died, leaving behind his widow wife, his son A, and daughter B. Here the property will be divided into three equal shares, that is one third each. So Y will get one third, A will get one third, and B will also get one third of the property. Section 51, Clause B. Where such Parsi dies leaving children, but no widow or widower among the children in equal shares. Illustration is, suppose X is a Parsi female. She died, leaving behind four children, two sons A and B and two daughters C and D. Here the property will be divided into four equal shares, one fourth each. So all A, B, C, D will get one fourth share in the property, which is equal share in the property. Section 51(2). It talks about where a Parsi dies leaving one or both parents in addition to children, or widow or widower and children. The property of which such Parsi dies intestate shall be so divided that the parent or each of the parents shall receive a share equal to half of the share of each child. So if a Parsi dies with two children and one parent, each child will receive one share and the parent would receive half of the share of each child, that is half a share. Section 54 talks about division of property where intestate leaves no lineal descendant but leaves a widow or widower or a widow or widower of any lineal descendant. Where a Parsi dies without leaving any lineal descendant but leaving a widow or widower or a widow or widower of a lineal descendant, the property of which the intestate shall be divided in accordance with the following rules. The first rule again here is if the intestate leaves a widow or widower but no widow or widower of a lineal descendant, the widow or widower shall take half of the said property. So suppose X, a Parsi male, dies leaving behind only his widow wife. Then Y will get only half of the property. Section 54B says if the intestate leaves a widow or widower and also a widower of any lineal descendant, so his widow or his widower shall receive one third of the shared property and the widow or widower of the lineal descendant shall receive another one third. Or if there is more than one such widow or widower of lineal descendant, the last mentioned one third shall be divided equally among them. The illustration is suppose X, a Parsi male, died leaving behind his widow Y and his predeceased son A's widow B. Here Y will get one third, B will get one third. Here I have also tried to give you the understanding of what predeceased means. Predeceased means a person who died during the lifetime of the deceased whose property we are talking about. In this illustration, the son A died before his father X's death. So, in simple terms, just remember that the son died before his father's death, means son is predeceased. Section 54C. If the intestate leaves no widow or widower, but one widow or widower of the lineal descendant, such widow or widower of the lineal descendant shall receive one third of the said property. Or if the intestate leaves no widow or widower, but more than one widow or widower of lineal descendants, two-thirds of the said property shall be divided among such widows or widowers of the lineal descendants in equal share. The illustration is X, a Parsi male, died leaving behind B, the widow of his predeceased son A. B will get one third property. If X, a Parsi male, died leaving behind B, the widow of his predeceased son A, and C, the widow of his predeceased son D, both the widows of his predeceased son will collectively get two-thirds of the property and then they will equally divide it amongst themselves. Section 54D. It says the residue after the division is specified in clause A or clause B or clause C has been made shall be distributed among the relatives of the intestate in the order which is specified in part 1 of the schedule 2, and the next of kin standing first in part 1 of that schedule shall be preferred to those standing second, the second to the third, and so on in succession, provided that the property shall be so distributed that each male and female standing in the same degree of propinquity shall receive equal shares. Schedule 2, Part 1, which is again associated with Section 54. Let me just give you the overview that what is there in that schedule. It starts with the first entry, father and mother. Second is brothers and sisters, other than half brother and sisters, and lineal descendants of such of them as shall have predeceased the intestate. Third is paternal and maternal grandparents. Fourth is children of paternal and maternal grandparents, and the lineal descendants of such of them as have predeceased the intestate. The fifth entry says paternal and maternal grandparents, parents. Sixth, paternal and maternal grandparents, parents, children, and the lineal descendants of such of them as have predeceased the intestate. Section 54E. If there are no relatives entitled to the residue under clause D, the whole of the residue shall be distributed in proportion to the shares specified among the persons entitled to receive shares under this section. Coming to the consultation paper on reforms of family laws. The old Section 55 was replaced in 1991 with a new one to ensure equality of genders by making the share of females in the same degree of propinquity equal to that of the males. Section 55 applies when a Parsi intestate dies leaving behind neither lineal descendant, spouse, relict, or nor any spouse relict of any lineal descendant. In such a case, the property devolves upon the relatives mentioned in Part 2 of Schedule 2 in order to their mention. Section 55 talks about division of the property where intestate leaves neither lineal descendants, nor a widow or widower, nor a widow or widower of any lineal descendant. When a Parsi dies, leaving neither lineal descendants, nor a widow or widower, nor a widow or widower of any lineal descendants, his or her next of kin, in the order set forth in Part 2 of Schedule 2, shall be entitled to succeed to the whole of the property of which he or she dies intestate. The next of kin standing first in Part 2 of that schedule shall be preferred to those standing second, the second to the third, and so on in succession, provided that the property shall be so distributed that each male and female is standing in the same degree of propinquity shall receive equal shares. Schedule 2 Part 2, which is related to Section 55, is father and mother, entry number 1. Entry 2 is brother and sister, other than half brother and sisters, and lineal descendants of such of them as shall have predeceased the intestate. Third is paternal and maternal grandparents. Fourth is children of paternal and maternal grandparents, and the lineal descendants of such of them as have predeceased the intestate. Fifth is paternal and maternal grandparents' parents. Sixth is paternal and maternal grandparents' parents' children, and the lineal descendants of such of them as have predeceased the intestate. Seventh is half brothers and sisters, and the lineal descendants of such of them as have predeceased the intestate. Eighth is widows of brothers or half brothers and widowers of sisters or half sisters. Ninth is paternal or maternal grandparents, children's widows or widowers. Tenth is widows or widowers of deceased lineal descendants of the intestate who have not married again before the death of the intestate. Section 56 talks about division of property where there is no relative entitled to succeed under the other provisions of this chapter. Where there is no relative entitled to succeed under the other provisions of this chapter to the property of which a Parsi has died intestate, the state property shall be divided equally among those of the intestate's relatives who are in the nearest degree of kindred to him. Now coming to the Parsi excommunication. What is Parsi excommunication? Parsi excommunication refers to the denial of religious privileges such as entry to temple and participation in rituals for those who marry outside the community, particularly the women. Highly discriminatory against women, as this is not applicable in a similar fashion if a Parsi male marries outside the community. He is still considered as a Parsi only on the basis of whether it's a Parsi male or a Parsi female. These rules apply on them. So simply, you just remember that Parsi excommunication means when a Parsi female she marries outside the community, means if she has married, suppose, a Hindu, a Muslim, or a Christian, she is treated as excommunicated from Parsi community, and it is presumed that she has taken the religion of her husband. So she is no more belonging to Parsi religion, and that's why she also loses her property rights. Not only that, she also is denied of religious privileges such as the entry to temples or participation in rituals, etc., etc. A landmark case in this regard is Gulru Gupta versus Barjot Pardiwala. In 2012, the Gujarat High Court in this case held that by marriage to a Hindu man, a Parsi woman ceases to be a Parsi unless a competent court declares that she has continued to be a Zoroastrian after marriage. The petitioner, which was Miss Gulru Gupta in this case, was refused the right to enter the Parsi institution in her hometown and the right to perform the last rites of her parents if they passed away. Finally, the Supreme Court provided her with this right through an interim order. However, the interesting thing is that this order is still interim order and the final verdict is yet to come in this regard. And in this case, Supreme Court has given her the right to perform the last rites of her parents when they will pass away, but the Supreme Court is silent with respect to the property rights of a female once she marries outside the Parsi community. So that is again one of the very important things which is yet to be decided. Testamentary disposition of property in Christians and Parsi. Section 59 of the Indian Succession Act 1925, it governs the testamentary disposition in cases of both Christians and Parsi. Means if suppose the Parsi male or a Christian male, they have left behind a will. In that case, the provision of testamentary disposition is provided in the Indian Succession Act itself, and it is starting from Section 59 onwards. Section 59 says persons capable of making wills. Who can make a will? Every person of sound mind, not being a minor, may dispose of his property by will. So you have to see that person is not a minor, plus the person should not be of unsound mind. So if the person is of sound mind and is not a minor, he is capable to dispose of his property through a will. Explanation 1 says a married woman may dispose by will of any property which she could alienate by her own act during her life. Explanation 2 says, persons who are deaf and dumb or blind are not thereby incapacitated for making a will if they are able to know what they do by it. Explanation 3 says, a person who is ordinarily insane may make a will during interval in which he is of sound mind. Explanation 4 says, no person can make a will while he is in such a state of mind, whether arising from intoxication or from illness or from any other cause, that he does not know what he is doing. Illustrations. First illustration is, A can perceive what is going on in his immediate neighborhood and can answer familiar questions, but has not a competent understanding as to the nature of his property or the persons who are of kindred to him, or in whose favor it would be proper that he should make his will. In such a circumstance, A cannot make a valid will. The second illustration is, A executes an instrument purporting to be his will, but he does not understand the nature of the instrument, nor the effect of its provisions. This instrument is also not a valid will, because the person is doing it, but he is not understanding what he is doing. Illustration number 3. A being very feeble and debilitated, but capable of exercising a judgment as to the proper mode of disposing of his property, makes a will. This is a valid will. Coming to the concluding parts. In India, Christians and Parsis are governed by the Indian Succession Act 1925 for succession. It is pertinent to note that in both Christian and Parsi succession laws, you will find gender biasness. Christian law is discriminatory against the Christian mother. Parsi law entails excommunication if a Parsi female marries outside the Parsi community. Indian constitution provides equality, but such provisions are glaring examples of violation of the Constitution of India. One common thread which is connecting every religion is the gender discrimination. It is important to change such laws and make equal provisions for all, irrespective of which gender they belong. Currently in our country, Uniform Civil Code is in debate. The Law Commission of India has cautioned through the consultation paper on reform of Family Law 2018. This report came on 31st August 2018, and the experts have provided their opinion that a uniform civil code is neither necessary nor desirable at this stage. This is what the Law Commission of India has provided through this report. However, it is presumed that if UCC is implemented, then all such discriminatory practices which are against women will be struck down in one stroke, and the constitutional mandate of equality will also ultimately prevail. Now coming to few questions and answers. Question number 1. In India, which law governs Christian and Parsi intestate succession? Options are: option number A is the Indian Succession Act 1925, option number B the Parsi Succession Act 1983, option number C the Christian Succession Act 1876, and the last option is the Christian and Parsi Succession Law 1932. Here you all know through the discussion that it is the first option, that is A, Indian Succession Act 1925, which is the correct answer. Question number 2. What do you mean by Parsi excommunication? The first option is when a Parsi stops communication with another Parsi. Option number B, when a Parsi female marries outside the Parsi community, she is not treated as a Parsi anymore. Option number C, when a Parsi male marries outside the Parsi community, he is not treated as a Parsi anymore. Option number D is none. Here the correct answer is option number B, which says when a Parsi female marries outside the Parsi community, she is not treated as a Parsi anymore and she is excommunicated from the Parsi community. Question number 3. Suppose a Christian son dies intestate, leaving behind his mother and father. What will be the share of the parents in the deceased son's property? The first option is both the mother and father will get an equal share of the property. Option number B, only the father will get the entire property, the mother will get nothing. Option number C, only the mother will get the entire property, the father will get nothing. The last option is the father will get 2/3 of the property and the mother will get 1/3 of the property. The correct answer is only the father will get the entire property, the mother will get nothing. Question number 4 is suppose Robert, a Christian man, has 3 children, John, Mary and Henry. They all die before Robert. John leaving 2 children, Mary 3 and Henry 4 children. Afterwards, Robert also dies intestate, leaving those 9 grandchildren and no descendant of any deceased grandchild. In such a circumstance, who will get what? The first option says the property will be divided into three parts, and then according to the number of children, it will be further subdivided into equal parts. Option number B says John's children will get 1/6 each, Mary's children will get 1/9 each, and Henry's children will get 1/12 each. Option number C says each of his grandchildren will get 1/9. Last option says none. The correct answer is C, which is each of his grandchildren will have 1/9 share. Question number 5. Suppose X is a Parsi female. She died intestate, leaving behind 4 children, 2 sons A and B, and 2 daughters C and D. Calculate their share. First option says the property will be divided into 3 equal shares. Out of the 2/3, the sons will get equal share, and out of the remaining 1/3, the daughters will get equal share. Option number B says 2 sons will get half share each, and daughters will get nothing. Option number C says the property will be divided into 4 equal shares, that is 1/4 each, and each will get equal share. Option number D says none. The correct answer is option number C, that is the property will be divided into 4 equal shares, that is 1/4 each. Thank you so much for the patient hearing. See you soon in my next video. Thank you so much.